Well, in this third video about the law of treaties, we will touch upon the things you need to know about what we have called the final phase on the conclusion of treaties. Let's have a look at it. So here, remember, we have looked at the initial phase consisting of negotiation, adoption, and authentication of the treaty. And we are going today to look at the consent to be bound by a treaty, the deposit and publication, as well as the entry into force. As I said, there is an intermediary phase sometimes when states need to take time to think whether or not they are ratifying after authenticating because they need to consult their parliaments, or because sometimes they want to sign, but they are not ready to ratify. Sometimes being a signatory is just a symbolic gesture, and the states are not really thinking of ratifying immediately. In addition, you need to be aware that this is the moment when states authenticate or when they manifest their consent to be bound, when they sign the treaty, when states can enter reservations or declarations to the treaty. They cannot do this afterwards. If a state decides it wants to enter a reservation or declaration after, it will need to withdraw from the treaty, get back into the treaty, and when signing or ratifying, enter the reservation or declaration. You have seen a bit more about this with Professor Sheivas, and I might touch upon it again during the class. So the consent to be bound is expressed normally through a signature, but there are many ways states have in diplomatic practice to express that consent by exchanging documents, like when I don't know, I'm sure many of you will have signed a rental agreement when you rent a house, and it is normal to sign it and to exchange documents with your landlord. Well, that's also done as a way of manifesting consent at international level. Sometimes it's a rubric. Anyway, states will have agreed. Sometimes, exceptionally, states can express the consent to be bound by the same signature they authenticate the treaty. That means that sometimes you will not have that intermediary phase for agreements that are easy, don't need the consent, they don't need approval by the domestic bodies, or whatever other circumstance. So it's important that you understand then that not all the states that authenticate a treaty and become signatories of that treaty will then become parties of this treaty, and the other way around. Some states that don't participate in the negotiations of the treaty or in the adoption of the treaty, or that participate but then they are not agreeing with the final text and may decide not to authenticate it, they can nonetheless sometimes, if that treaty is open to others, to ratify the treaty at a later stage. Let's have a look at this. Perhaps it's going to become clearer if you look at the Vienna Convention on the Law of Treaties itself. So if you have a look here, this is the 1969 Convention on the Law of Treaties. You will see that some states that were signatories that participated in the original negotiations and adoption of the treaty may never become parties of the treaties. They may never express their consent to be bound by it. You see, for instance, Afghanistan, that signed the treaty on the 23rd of May 1969, but has never ratified it. On the other side, you have next Albania, that was not a signatory of the treaty in 1969, but ratified it in 2001. Or Argentina, here, that was a signatory in 1969, but became a party in 1972. It manifested its consent to be bound in 1972. Please remember for later that you can see here examples of states that became parties that manifested their consent to be bound by the treaty before it entered into force, okay? While other states, for instance, Brazil, was an original signatory in 1969, but then took 40 years to decide to ratify the treaty in 2009. This is also the time, as I said, for states to enter declarations and reservations. So if you are on the right website, if you look at the official depository, which is the Secretary General of the United Nations and the UN website, you will find all the information about declarations and reservations. So for instance, you will have here from Afghanistan what we call a reservation that modifies an article. So Afghanistan has introduced a reservation that establishes a particular interpretation of Article 62. You will also have examples of declarations that have no legal impact. They are merely political declarations. For instance, Algeria established that the accession of the People's Democratic Republic of Algeria to the present convention does not in any way mean recognition of Israel, or other declarations like the one of Armenia that excludes a provision for itself. In this case, Article 66. Armenia is not bound by Article 66 of the Vienna Convention of the Law of Treaties. So basically, what this means is that you will have not only states that are parties and states that are not parties of a treaty, so you will have states that are bound by a treaty and states that are not bound by that treaty, but also within the same treaty, you will encounter states that are bound by some provisions and not by others, as long as the treaty allows that to happen. After states express their consent to be bound, they are meant to design someone who will be the guardian of the treaty. It's called the depository, and according to Article 102 of the UN Charter, all states should also make public their treaties with the United Nations. This is established in Article 102 of the United Nations that I have reproduced there. However, and we'll see some of these when we look into specific cases, if states decide not to follow this procedure to make public their treaty, it only means that they will not be able to invoke it later before organs of the United Nations. It does not mean that the treaty in question is not enforced or is not valid. Finally, once states have ratified the treaty, you will have provisions in the treaty itself establishing when that treaty enters into force. So a treaty can establish that a treaty enters into force when 50 states have ratified it. So until that moment, even if states have expressed their consent to be bound by the treaty, they are not legally bound until it enters into force. And we have seen some of the examples before.